Good morning, Honorable Committee, Chairman Lynn, Rep. Ball, and Rep. Kutab, and anybody else that I've forgotten that I've met before. My name's Robert Tangway. I'm the author of New Hampshire Oliver Twist. There's this bill I do support, but we have to look at this wide. There's a couple issues I can go into specifics with the bill that you guys should change, but there is a contention that pro se litigants don't know what they're talking about. Welcome to Revolution Day. All the bills you're going to hear today are about reforming our judiciary. Our judiciary is far more powerful. This is one of the most powerful committees in the House. And our judiciary says that they're the shield, but they use that shield as a weapon. We have a state of political protection and persecution and prosecution. They can choose, a judge can choose any outcome they want. What's concerning is actually Pendleton. I don't think he's a good judge. He put Justin Nato in jail for not paying, and he's currently in jail.
Excuse me, we're not going to disparage other members from other groups, judges or whatnot. So,
Okay.
We appreciate your opinion, but
Well, that's just a fact, but I'll respect that because that's not what I want to get into. So the previous person just mentioned the family court docket's extremely limited. And that's where all the problems are coming from, because when you go to family court, it's pretty much a private hearing where nobody's in there except for the parties, maybe the mother and such. I've been able to bring some other people. But when you go into the circuit court, criminal, superior court, there's prosecutors there. The judges act very well because other people are looking. But when you're in the family court, they treat you like crap. I have videos of it. Article 8 requires the government to be responsive and accountable, and that's what this does. So I like this bill. There's a couple things that I don't. So really what I want to say is we need to fund our courts better. We need more court time. The problems that you're having is because the judges aren't following the rules. They're not following the domestic violence protocol for victims against men. 86.4% of all child support cases are awarded where the man has to pay. I will send you the opportunity notice from the DOJ, this building right here, where they, in 6 separate paragraphs, train police, judges, and prosecutors. So the judges would be the family court judges that they handle DVs to only protect women using federal grant money. And then you have the statistical analysis of 86.4%. Men are getting treated poorly. And the women who are getting treated poorly, because it does happen, are usually less politically connected or do not act as a woman should, which is a victim. We have a victim mentality. That's what we need to shake. So the statistical analysis of case processing time, we need more time. They need less, but that's coming from Title IV-D grant money and the expedited child support process and contract, which the state has signed with the Supreme Court and the administrative courts to expedite. They get reduced funding, and if they don't have 75% of cases within 6 months or 90% of cases within a year. So she just said, oh, some people don't schedule out for a year. No, they gerrymander all that stuff. I don't want to get into the details of my case because it doesn't matter. What matters is what we're doing is holding judges accountable, which they are required by the Constitution. And we have a system of people who all know each other and are all working together to protect each other. And it all comes appointed from outside funding sources, the governors, the senators. They get more money from outside sources than they do inside. People are buying and selling our state. So statistical analysis of case processing time, I think that that's something that you guys should look at. Again, you guys have a job. You're going to exec this out. It's an important bill, and I appreciate it. Now, I also, on page 2, I think it's line 12, judicial officer fails to achieve an overall satisfactory judicial evaluation during 2 consecutive evaluations. Any. Nip it at the bud. The biggest thing that I had, I'm suing a lawyer now. The biggest thing that I had was how do you stop a judge from lying in real time? And the only way you can do that is sue them in federal court, which people are doing in New Hampshire. But then that freezes your case, and your case is frozen. So it's a really difficult thing. So we need to nip this in the bud. That's all I have for this bill. Thank you for hearing me out. If you have any questions, I'm going to be speaking all day today. So I'm very knowledgeable. I know the laws. I know the realities.
Thank
you. Robert Tangway. I support this bill, limiting judicial immunity. When you get to the U.S. Supreme Court level, just to let you guys all know, I'm supposed to wear glasses. I don't wear glasses. So you guys are a blur. I'm speaking from my heart. I can see a little bit. But anyways, Supreme Court, U.S. Supreme Court is kind of stagnant on this. There's 1983 lawsuits, right, that you can, but that's only when declaratory relief can or has been violated or cannot be found, which is super vague, right? So that's a 1983 lawsuit. The civil way, what's going on in Minnesota is horrible, no matter what side you are. I don't protest. It's to file lawsuits. That's what the rich people do. That's what the president does. He's suing Scanlon, not to without the merits, right? That's what you do. The courts are civil to relieve the pressure. This place is civil to relieve the pressure so that we're all peaceful. I reported judicial misconduct to the Supreme Court. They wrote denied. Rule 38, 2.15, clerk, which I reported to, and the lower courts in writing and on the phone, by not taking any action on reported judicial misconduct, in itself is an act of judicial misconduct. That's our entire Supreme Court currently. We have preferred litigants. Preferred litigants. That's what we have. Outcomes are already decided. The only protection from that is a jury. This will allow us to get to a jury. Hans Marconi, in one of her last opinions, she led the court, New Hampshire Supreme Court, saying that this court, Supreme Court, is often skeptical of sovereign immunity, especially when there's a law there. I think that has to go into play with her prosecution. So this is a law that says very clear that you can sue a judge. And you can't use judicial immunity in the state of New Hampshire. It'll get heard out. They can settle. Or it can go to a jury and the jury decides. And then they can settle anyways. And then the Supreme Court can overturn it and do all these things. Then you should be able to sue the Supreme Court. You should be able to sue anybody you want. Civil procedure. Article 8 already allows this. It already allows it. So this is just a law that allows you to do it. And so this is 14. So the Supreme Law of the Land in Article 14 is Article 8, the Constitution. Article 20 says a solemn right to a jury trial for any matter over $1,500. Judges caused me more than $1,500 in damage, for sure. So I will be suing them. Now it'll probably get dismissed and denied and and then you can go. But keep going, and then you'll get justice. Any questions? I'd be happy to answer, but that's, restatement of torts. So you guys need to look. So most of the torts in New Hampshire are common law. They're not specifically described. So then you have to go to the restatement of torts to find the damages and all that stuff, or causes of action. So when you guys are looking to put to bills, you might want to consider putting in like some teeth. It says civil tort proceedings, but you have to have a tort. And I haven't found a tort of fraud. So I'm certain for malicious prosecution and abusive process. That's where it's at right now in the Superior Court. Restatement of torts. We need more statutes.
Thank you, sir. Robert Tangway, please.
Good almost afternoon. Robert Tangway here. I support this bill. I haven't really fully understood it, but the reason that I do like it is that it provides a clear legislated opportunity to go forward with a claim. That claim might not go through, but it can't be barred because there's no cause of action. And then where there's disputed facts, the plaintiff and defendant will have to duke it out in mediation or whatnot. I don't have anything to say specifically about changing it because this is not one of the most important. Oh, wait, I apologize. I was looking at the wrong one. Okay, now I know exactly because I did read this. I'm a little wishy-washy on this bill. This bill is for relative to the appeals for convictions in circuit court, or is that what we're talking about here?
1509, House Bill 1509.
FN. I was correct. Okay, so to go back to that, anything that allows an action for a lawsuit and stops it from being disbarred is very important. So I do support this. I don't have any recommendations to change it because I'm not as fluent with this particular bill. So I'll just reserve my time for other people or have future bills, unless you have questions.
Right. Thank you. Questions for this witness? Mr. Tangway.
Thank you again, honorable committee. My name is Robert Tangway, and I'm changing to oppose this bill, and I have some reasons.
You're here in opposition to the bill. Okay.
Correct. I'm a victim of sexual violence. My first time in court was when I was 5 years old. I had no problem. I love it. It's one of my first memories. They did a great job, and it was attempted. So I was smart enough to stop it at 4.5, but it still went through. You're not a victim unless there's a conviction, and that's the problem that judges say. The victim, it's alleged victim. If there was no crime to be committed, it hasn't been proven that a crime was committed, then there is no victim. You can't just go in there and say that I'm a victim. That's a victim mentality. The thing is that I do understand bringing a alleged victim or victim in twice, but there's a famous saying. I think it's Ben Franklin. I'm not sure, but it's better to let 1,000 guilty people go than one innocent person get convicted. And the process of it is, if you're facing 10 years, you want to get it done as quickly as possible. You might make a decision, which brings you to a jury. But your life stops until you're innocent, and then it's always already damaged. Police, prosecutors, they all get to choose who to prosecute. Literally, you're immune. A prosecutor's immune, and the police are immune. For if someone was to go into the police station and say, hey, Bill, what's going on? Yeah, I killed the person. I did it, non-self-defense. I planned it all out. And then the prosecutor, and then the police go, yeah, well, we're just deciding not to arrest you. Literally, they have prosecutorial immunity, and they have immunity. So you have an alleged victim. There's a case in Manchester that happened recently where a police officer got charged with domestic violence. I won't say his name because he was acquitted on a bench trial. And the only reason why I think there were charges is because the person alleging it had a lawyer. So the police didn't want to get sued, so they referred it to Attorney General, and then the prosecutor didn't really try. There was so many mistakes, and then he got off. But they're not prosecuting the woman for lying. So it's all about reform. So the penalties are very, very high. And if a jury hears, they're not gaming the system. The system's already gamed as they charge whoever they want. So that it's very important that people have a jury trial. I would be okay with this if there was an opportunity to then change later. What if you get a biased judge? Like literally, it's up to the judge. It's up to the judge if you have a bench trial, and they could pretend. But then there's also time for the parties to come together and come up with a deal. The deal is reform. So that's what it's not to extinguish humanity as required by the Constitution. It's for reform. Now, sexual assault, I don't know what kind of sexual assault would be a misdemeanor. I mean, I guess getting drunk and not having consent, but like if you bring a weapon into it, that's gotta be a felony. That's pretty much it. So I do oppose this unless you amend it to have a second bite at the apple. You should have as many bites at the apple because it's good for reform. I don't believe in the death penalty because you need to find out why the person did it so that it doesn't happen again. And I think it's very important that we don't box someone into a bench trial. Thank you.
Thank you. Questions for this witness? Seeing none, thank you very much, sir.
Saving for after lunch.
Is
Robert Tangway here. I'm for this bill. I'm very upset actually that you guys ITL'd the two other bills.
Let's go, but let's focus on this, okay?
There needs to be some corrections, and it all ties together. So the totality of the circumstances, which is by Supreme Court, U.S. Supreme Court, recent ruling, I think in the last session. You have no way to sue a judge. You can sue a judge, but it will get dismissed. Absolute immunity, civil immunity. That even extends to 1983. The only way you can bypass that is if they lack all jurisdiction. All jurisdiction, meaning they're not in the courtroom, they're not judges. So you guys need to reconsider that. This bill's immense. But it stems from Article 8 of the New Hampshire Constitution. And holding government officials accountable, well, you go to the police or you call the attorney general because someone stole your kid and took him out of state violating 633:4, which is a felony, which would require a grand jury indictment, because that's what grand juries are for, is for felony charges. That's how you push it through. There's actually a statute. I don't know the one often, but I guarantee you there's a statute, because I've read it, where it requires before they start prosecuting, they have to have a grand jury indictment for felonies. So Hans Marconi, felony indictment. Justin Nato, felony indictment. Secret. One-sided, as they said. One-sided. Now, this is basically to, in my view, is to hold the government accountable. You all have your own interests. Okay? You're not doing it for $100. Maybe you're doing it for legacy. Somehow you're able to afford to be here. I have to go DoorDash to be here. I was homeless for a year because a judge wrote physically and mathematically impossible findings of fact, and then the lawyer conveyed those for a very long time. So there's no relief. So if the police protect the judges, and the judges protect the judges, and the lawyers protect the judges, and the attorney general protect the judges, and the judges are all lawyers, and only one of our Supreme Court justices was ever a judge, and they're all appointed by Governor Sununu or Kelly Ayotte. It's like Sweezy versus New Hampshire, where it was all Republican. So there needs to be a third party, and the third party is the people. We have all sovereign rights. And it's the 250th anniversary of our Constitution and the Declaration of Independence. Our Constitution came out first. So I recommend some changes to this, though. I think that you guys should reconsider the previous bills that you ITL'd and instead have this go to study. And then you can look at that holistically, because this can be abused too. We live in a republic. If everybody says Robert Tangway is a bad guy, I have constitutional rights. They can't do it. You can't vote on me. a big problem with power and money in politics, and this committee is here, in my assertion, to protect the judiciary. That's what it's here for. And those ITLs were voted ITL because they don't want to expose our judiciary, which we have a constitutional right, Article 8. The government shall be accountable at all times, the government. Further, the judges are required to be bonded. They're not bonded. Chapter 93. So nobody's doing their job. This provides a way for the people to gather 500 signatures and do the job for them. It's a one-sided thing, but that's, I guess, what a grand jury is. So that's where I'm coming from with this. And also Article 8 stems with 91A requests, which the government constantly denies and sends you in circles. So Article 8, the people with a petition of 500 can investigate anything and get all these documents, the documents that are trying to be hidden. So I do support this bill, but I think that it needs a little bit of work, and I would think it would as a couple limitations so that it can't be abused against people. Corporations have a contract in the state of New Hampshire to follow X amount of bylaws, just like when you get married, just like, and also RSA 311:1, any person can prosecute. That's what it says. And 311:6 says that a lawyer has to take an oath to not do anything for lucre or lucrative. Our government is for money. You guys are here for money. You guys are connected to money. Ms. Smith's connected to previous Administrator King, judiciary. We have a problem. That's why these bills all today exist, because we have a problem. I would really appreciate some questions, especially going forward, because I believe that I'm not being fully heard and considered without any questions, especially when you vote against. And I can't coerce you to do anything, but I can try to persuade you. And if you have any questions, I'd be happy to answer them.
Questions for this witness? Seeing none, thank you very much, sir.
I would like to commend the committee, though, for giving people time to speak. That is very important, and I appreciate it.
Thank you. All right, next, I'm going to, Patrick Binder, please.
All right. Good afternoon, everyone. Patrick Binder from Manchester. I'm here with New Hampshire First. We're a citizens advocacy group, and I think this is generally a pro-citizen bill. It was said earlier that this doesn't create anything new. It actually just adds structure to something that already exists. It's not in our Constitution directly, but Article, Article 90.
All right. Robert Tangway here, author of New Hampshire Oliver Twist. I recommend that you guys all read it. Be working on modern Oliver Twist eventually. I am not in support of this bill, unfortunately, and I have great respect for my elders and the wisdom, especially Rep. Lynn. I love hearing him speak, and I think he's thoughtful. But there's a saying that I wrote. You can't teach an old judge new tricks, but it's easy to trick an old judge. So my first time in court in New Hampshire, besides when I sued Amazon, which the FTC took up that case on the same grounds and was denied by Gordon MacDonald when he was Attorney General. I had a referee who just recently retired, and she wrote physically and mathematically impossible, not likely, not more than likely, ponderance, and that is why this is the first time I spoke in the State House. It was afterwards, and I've been retaliated against it. She wrote that I looked into a sliding glass door that doesn't exist, that I initiated 1,100 texts for 3 months, no legal standards, and I haven't seen my children in over 3 years because of that. And you want to hear a man howl, cry, take away his children, especially on. I was never arrested, never charged. They went to the. We found out now they went to the police, and
What does this have to do with the age of a judge?
because a judicial referee wrote down physically and mathematically impossible findings of fact, impossible, and then they destroyed the evidence, knowing that a judicial complaint was filed with the Supreme Court. It's really horrendous stuff. There's ego. There's also wisdom. I would agree to this if our judiciary wasn't so corrupt and disheveled. Government is inherently corrupt. That's why we have a constitution. I could never be a judge. My ego is through the roof. That's because I came from nothing. I have to. That's my defense. We want wise judges, not teeny boppers, I'll call them, which is who reviewed first time rookie. We want the wisdom, but again, they make mistakes. And I feel that this bill would have the effect of elongating political appointments, which is the problem. That's the real problem. I will say that my videos get more views than just all the legislators. So if you guys ask me some questions and want some good promos, if you ask a good question, it shows up and thousands of people see it. So that's my testimony. I just want to reiterate that a 70-year-old judge, a judicial referee, wrote physically and mathematically impossible findings of fact that have been transmitted all across the state, including now. So the officer who was there, if you get pulled over, it shows that I looked into a sliding glass door that doesn't exist. That's fraud, and fraud unravels all. So I have to get things situated so I can see my children, but we have to deal with other things. So I think that this would be something that could pass, just not now. And there's other opportunities including in the last bill, for retired judges to make $800 a day almost. It's a lot of money. Thank you very much.
Thank you. Any questions?
Okay, so I actually have the legislative book, and I've talked to the clerk. Article 72A is not completely, fraudulent. The voters were presented, and then after it was voted on, they added a sentence, the legislator, from what I can procure, added a sentence that the rules shall have the force and effect of law. Fraudulent. That's our government. And this was after Sweezy versus New Hampshire, where it was returned from the Supreme Court, the U.S. Supreme Court, Cold War sedition. But before, I believe, I thought it was in 77, but the 200th anniversary was in 76, right? And then now we're at the 250, but it doesn't fall on a cool little 76 year. But it's a better number, 250. And you'll see that with the history of the legislature, as I read all the laws now to get my life back in order, you'll see that after these times, there's a lot of movement back to the Constitution and such. But this is fraudulent. And so it was done for political means by the elite to gain power. They literally added words to our Constitution after it was voted on to give the force and effect. So all the court rules, the rules of evidence, the Superior Court rules, the Supreme Court rules, have the force and effect of law. I don't have to follow court rules, especially if they're repugnant to the Constitution. Lawyers have to. They took an oath to do that. A lawyer is a officer of the court. Their first duty is to the court. Second duty is to their client, which is a ward of them. The ward, incapable of representing themselves, taking liability off the client for the most part. But to the court also is to the opposing counsel and opposing party. So that's why we have this big problem where all these rules have the force and effect of law with a fraudulent constitutional amendment. In order to rectify this, I don't know the exact process. This should pass, but I bet there's another way to do it. I bet you can actually remove, I don't know how, remove the last sentence. And then it will be okay. At least it won't be fraudulent. And so that's where I'm really at. But it's a real big focus on the court rules. They can waive anything. 1.2, same thing in Superior Court. The rules of evidence, they can waive the rules of evidence, all on a whim. Lie, cheat, and steal, hope you fail on appeal. That's what happens. I've had 3 Supreme Court appeals, all for procedural issues. They struck my brief, all while Hans Marconi is getting indicted. Like, it's ridiculous what's going on. But this is just more evidence of the government is inherently biased. A lot of people that sit in, especially family committee, don't know the law. They don't know anything. They're like, I want to be on a committee. I think it's the people that run the committees that do know. And that's why I asked for your leadership, Mr. Lynn, because you do know what's good. And I think you're a good person. I don't think people wake up and go, let's screw Robert Tanguay over. Let's screw the poor over. I don't think that they have the understanding, because if you go through the judiciary, if you go through, which the lawyers are, judges, their whole family's judges, just generational wealth gets passed. And then people who get affected by bias, and the judges aren't following the laws. I have it all written, like they have it, signed affidavits. You have left with no opportunity to better one's station in life. And that's what this is really about. That's what our Constitution's about. And to have a judiciary create law on fraud, it's pretty self-explanatory. I'll be happy to take any questions about the court rules, the family court rules specifically. I think that's the isolated area of unsettled law and where we're having most of our problems. You go into Superior Court, those judges are seasoned and such. Are there any questions?
Questions for this witness? Seeing none, thank you very much, sir.
I would like to remind you all that you have a duty to repeal this. I will send you the actual voting logs registered. I have it all. Thank you.
Okay.
All right, Robert Tanguay. And we're almost done here. I support this bill. The previous speakers, also members of the House, made some good points that I already had. I think it was McFarland. So Rule 38 of the New Hampshire Supreme Court, 2.15, makes judges and clerks mandatory reporters. But it also says that this is not the grounds for any legal action. This is kind of weird. However, RSA 311:6 requires lawyers to basically do the same under the pains and penalties of perjury, an oath that they willingly took. And since all judges took that oath, because all judges are lawyers in our state for some reason, this already exists. Now, perjury, that requires a grand jury indictment. Nobody's going to do anything about that. So this bill handles that. But again, civil tort liability, I looked it up because I was like, the first thing, like, it's super vague. It goes anywhere from like due process violations. So I think that needs to be tuned up. This is a very important bill, by the way, guys. Very important. Okay, but it just needs to be tuned up as people, and that's where you guys get to speak. I'll be watching you guys exec this, and I really want you to work through it. I mean, this is a pivotal time in our history. So that's 311:6, perjury. That's an oath that they take, and this basically just adds to criminal. I would like you guys to add, consider a civil cause of action, so that you can sue. Because otherwise you're left with the restatement of torts, which I brought up earlier, where you have to find a common law tort. And this is like evolving cases that are happening in Superior Court with my lawsuit. So I'm getting this back. I mean, the way I see it, it's really simple. Someone hurt you, they weren't supposed to, you can sue. Personal injury, right? But then they like to come up with all these deviations, and even if they're right or wrong, if you're not represented, if they don't like you, lie, cheat, and steal, hope you fail on appeal. And appeals are very hard. Top-notch stuff. I got a GED. I still wrote excellent papers, which people have said are very good. So I want you guys, so those are the things that are really important, okay? These things already exist except for the criminal, but then there's a criminal perjury. Now we're talking a misdemeanor. The grand scheme of how our judiciary should run, more lawyers, so make it easier to become a lawyer, smaller penalties for lawyers and judges, and more frequent escalating. So to get people on track, we all make mistakes, but the lawyers are a racket, which violates Article 83 of monopoly in the state of New Hampshire. They are the only ones who are allowed to practice law, and they're going to hold on to it. When I was at the Supreme Court, a gentleman, a security guard, ex-CIA agent, gave me a book by Bastille called The Law. And it's a great book. It's a short one. It's like a bathroom read. But it's pretty intense, and it's famous. And it's basically like all industries monopolized. There's all in interest. Franklin Pierce, monopoly. So I'm glad we were able to discuss this stuff. I think that you guys should pass this as written, but it would be better if you guys amended it to clarify the civil, and then add a right of action, meaning you can sue for this for personal injury.
Thank you. Questions for this witness? Seeing none, thank you very much.
Thank you very much, everyone.